Hello again. In the last chapter of the book, Lost to the Races, I made a few observations, and one was the contradictory approach that Britain operated towards China, in that it seeked to essentially trade with China and enjoy the benefits of that, um, and also to try to adopt this superior moral stance where it felt that it had the ability to advise China on how it should manage its society and so on and so forth. And often that's in the role of human rights, and which are very, very contradictory. And how I felt that you can't really do both at the same time. Effectively, if you're going to trade with China, you have to accept the country for what it is and how it's managed, and you don't have any rights to dictate to it in terms of how it should operate as a society. Now, the other observation I made, bearing in mind this was April 24, was that in essence I saw this before he'd been elected, but it was fairly obvious what was coming. I felt that Keir Starmer essentially was just a legal industry frontman, and I also made observations of how the first past the post system is a managed democracy. It's not a what you would call a credible democracy, and I think we've seen that in terms of Starmer's vote share and his huge majority. But on the legal industry frontman, what I mean by that is this concept of really we're ruled by the tyrannous rule of lawyers, not the rule of law. And essentially, what Starmer's role in that is to ensure that vertically integrated line of corruption between the political and the legal sector is still in place. And to demonstrate these two observations, I'm going to now look at the collapse of the alleged China spy trial, and how Starmer has sought to mislead the public in how this collapse has come about. He misleads the public virtually every time he opens his mouth. There's nothing new on that. As a prime minister, almost his strength is his weakness. He's embroiled in so many scandals that the scandal will break, and barely can it properly be covered, and the next scandal breaks as well. So the pub, we don't really have a free press in Britain, so the public are really left in a bewildered state. So I've used a few examples in the description. I pasted in some links, and I'll make reference to those. So the first is the Sky News article, which I've put the link in the description, and I'll quote from that in terms of the Prime Minister, in terms of his explanation for the collapse and why he's not telling the truth. The Prime Minister has maintained that because the last Conservative government did not designate China as a threat to national security, his government could not provide evidence to that effect, which the Director of Public Prosecution, Stephen Parkinson, said was required to meet the threshold for prosecution. Now, there's a few things to note about this. One is, if you follow the article down, there is, just trying to scroll down here, there's a quote from an academic of public law, and I agree with him here, and I'm going to quote: Mark Elliott, Professor of Public Law at the University of Cambridge, told Sky News there is no legal requirement for a country to be declared an enemy for someone to be tried for breaching the Official Secrets Act. He is absolutely correct here, and I've pasted in the link to the Official Secrets Act, and you can scroll through it yourself, and there is not one mention of a threat to national security or being deemed an enemy. And Starmer knows this full well, so he knows he's misleading the public. So I agree with Mark Elliott totally here. There's another document that I would advise you to see, and I'm going to go to it now, and it's actually a notice that was issued by the it's basically a designation notice under section blah 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 of the Communications Act 2003 designating Huawei for the purposes of a designated vendor direction. Anyway, this notice was signed off by Michelle Donnellan of the previous government in the role of Secretary of State for Digital, Culture, Media and Sport on the 12th of October 2022. So this was in the last government. I'm going to quote from you part of this. So I'll just manage to collapse it because you'll find it very interesting. So this is under the reasons for the notice, and it's 4B, so paragraph 4B. I'm going to quote from that. Practices of the Chinese state, coupled with the way in which it operates laws such as the Chinese National Intelligence Law 2017 (amended 2018), can enable the state to require companies based in China and their employees to engage in activities which are harmful to the United Kingdom. Remember, this was the move to remove Huawei from sensitive telecommunications infrastructure in the UK. The way in which these rules are operated means such companies can be required to direct their subsidiaries to engage in activities which are harmful to the United Kingdom. Huawei's employees can be required to comply with directions issued by the Chinese state without the knowledge of Huawei. These powers give rise to a risk that covert and malicious functionality could be embedded in Huawei's equipment. So, the idea that the government hadn't designated China as effectively an adversary, that's, I'm quoting from this and not giving a personal judgment on that, is lies. And so you can see Starmer is twisted and perverted, trying to twist and pervert the law in a way to try to lie his way out of providing an explanation as to why this trial was collapsed. And that is a perfect example of the rule of lawyers, not the rule of law. And as much as people discuss liberty as at current times, you won't get your liberty back until you break this hold that the legal profession have over us in terms of the rule of lawyers, not the rule of law, this perversion of the law. And I've given many examples throughout these series of videos of that, of how prejudice is used and perverted to prevent the rule of law occurring naturally, how essentially we've got these situations of the gross perversion of the ECHR, where we can have George Galloway, who's taken off a plane and interrogated by armed officers, not told why, hasn't committed any offence that he knows of, for 5 hours told he can't leave but he's not under arrest. And yet you've got migrants who can somehow conspire with crooked lawyers to prevent deportation over the most spurious of reasons. Now, it can't possibly be under the same act, of course. It's the distortion of the act, not the act itself. No other country in Europe really has the issues on the scale that Britain does with it. And look at Jess Staley. How can his outcome be reconciled with Peter Mandelson's outcome, and he's still able to carry the title of Lord? How can that occur under the same act? Because Staley was operating here in the United Kingdom and qualified to be treated under the ECHR in a way that the FCA approached that. It can't possibly be reconciled with Peter Mandelson. That's an example. The other perversion that I would say is look at this slavish devotion that Hermer and Starmer made to the concept of international law in the Chagos Islands deal. And yet, whatever you think of Russia, and you're entitled to your views on it, and I've said I don't understand the reasons why they did invade Ukraine. I can't justify it personally, and I'm not comfortable with shelling civilian areas and infrastructure as winter comes. But the Ukrainians have also committed atrocities the other way as well. I would argue the Russians have committed more atrocities than the Ukrainians, but they both have have done bad things. But to seize what we term as immobilized or frozen assets of Russia, and to provide the funds to Ukraine to buy weapons to use against Russians, that for that to happen would have needed to go through international law, and it hasn't gone through international law. It's been an arbitrary decision. So you can see the manipulation of the system. When it suits, international law is king. When it doesn't suit, we can just make an arbitrary decision, and you've seen that throughout this series of videos. For what it's worth, all countries spy on each other, and the UK has got a difficult situation with China because it's not militarily strong enough to confront it, and it's not economically strong enough to decouple from it. So it's in this silly void of, well, we need to trade with China, but we'll try to use phony concepts to try to assume moral superiority to tell them how to run their society. So this is really why this trial has collapsed effectively, because the embarrassment that it possibly could cause. But the UK, if you go back to the unrest in Hong Kong prior to COVID, the UK and the Americans were certainly active in stoking that unrest, and I think it's disingenuous if people don't recognise that. The UK, isn't a military power anymore, so it has to use its what bit of influence it's got, and in different ways. And now if you look at the Ukraine war, which is effectively a shadow war against Russia, anybody with any analytical capability will recognise it as such. But it's not just in Ukraine. The UK and its allies are actively trying to destabilise Serbia as we speak. The Republic of Srpska, which is the Serb-dominated area of Bosnia-Herzegovina. Moldova, it's another line of where there's the same activities happening. Georgia, and to a certain extent, Romania. So in terms of Georgia, for what it's worth, there are Georgian businesses trading on the London Stock Exchange, but people, if they do invest in them, do have to be mindful of these covert activities, this pull, this wrestle for control from east and west, in what is effectively a fight for the Eurasian landmass. They do have to factor that in mind when investing in such, but I assume they do so. So I hope that's kind of given some colour behind the observations I made in 2024, and I tried to use current examples to make it more clear. You may have also noticed when Starmer was in India and he answered questions about digital ID. And this has been picked up by others as well, so I'm not telling you really anything that's new. He seemed to justify it in the concept that you can access what you're already entitled to access, your cash, public services which you've already paid for, and so on and so forth. So what it essentially means is the digital ID is going to come, what we all know is going to come with an embedded conditionality. So that's really the threat to your liberty, which you've got to decide whether you're willing to accept or not. They will, of course, try and push it on you. If they can ram it through Parliament without a revolt, what they'll try to do is it'll be similar to COVID, where in essence you won't be able to do anything without it. They'll bully all the companies and institutions to accept it. So you either use it or you go off into the hills and play with sticks and stones. So it'll be forced on you in that way. Obviously it wasn't part of their manifesto, and you can obviously all understand why that is, because they wanted to deceive you in gaining election. But that's a concept. I mean, if you go back to the rule of lawyers, Starmer is the example of that. If I've explained to you, it's ridiculous that people expect him to solve immigration, the immigration crisis that we face. because he made so much money from that process as a human rights lawyer. What Starmer learned to do is he didn't have to put his cases in front of juries. He just learned how to bend the system and manipulate the system, which is what he's doing now as Prime Minister, to make, in his words as a lawyer, I made quite a lot of money. A lot of money to buy a field for donkeys to graze, for instance, and much more besides. So he's not going to do anything that's credible. If he's under pressure, he'll try to do something to bring it down a bit, but he's not going to, because his profession makes so much money from it. It's not about smashing the gangs in isolation. You've got another gang here. They wear shirts and suits and blouses and so on, and they feast on the migrants, and they come here and make an awful lot of money from them. So you're asking really the fox to guard the chicken coop. And it's an extraordinary concept. So I guess look at the number of MPs in Parliament who are legal professionals. It's all designed to play this corrupt rule of lawyers to take away your liberties and to ultimately draw down on your cash. If you look at Starmer, his history of his cases, he'll say he was operating privately, but ultimately all his money came, vast majority of his money came from the third estate, the private sector, because he was challenging ultimately public sector institutions, the public sector, and drawing down massively on that. So he's not going to do anything that will disrupt his core profession too much. He'll do just enough to try to keep the pressure off it. And that's ultimately what you've got to bear in mind. I mean, just out of passing, we were you've seen, I've shown throughout a series of videos how the FCA also with their work with the legal profession grossly manipulate and distort the law. I've shown you over the Staley case and the Woodford case. We were looking at that. It's very interesting when we looked at it, because you could see the issue they had with Link, for instance. They entered into this scheme of arrangement because they knew there were big risks of taking on Link legally in an open forum, because Link would defend themselves, and Link would have almost certainly said that, hang on, you're saying that we breached these parts of regulation and so on and so forth, or failed to do this, failed to do that, but you were informed of the process right the way throughout. So the FCA couldn't take a risk with that. So that case actually conforms perfectly to the hierarchy of greed that I've spoken of so often, and that is effectively number one priority: protect the reputation of the regulator, to the vast remuneration of legal professionals, and then the third priority is the victims. The scheme of arrangement ultimately would have earned legal professions an obscene amounts of money, and that's been undisclosed because you can keep it nice and quiet. And that's the way it sort of rolled. Now the challenge, and we've been watching this, and it's quite funny in some ways. The challenge the FCA have now is the fact that Woodford is challenging their findings against him. These very same issues that they tried to cover up in their scheme arrangement with Link are going to come to the fore, because Woodford will show that the same effectively. That I don't know whether Woodford will be able to clear himself of what's been placed against him, but in the process of trying to, he will expose the fact, I imagine, that the FCA were fully appraised of developments and grossly neglected their consumer protection obligation, and let consumers face the worst case outcome of a fire sale of assets. So it's quite interesting seeing how they're trying to prepare themselves to try to cover that, but it's going to be very, very difficult. And it's really that concept that I raised in Lost to the Races, of two sides of the same coin. Anyway, that's enough for now, and I hope you found that useful. Take care.